Welcome to FinTech Focus, Skadden's podcast for fintech industry professionals. The global regulatory and legal updates you need start now.
Hello, and welcome to another episode of FinTech Focus with me, Joe Kamyar. And joining us today is our cybersecurity lead in London, Nicola Kerr-Shaw. So, Nicola, welcome back.
Hey, Joe. Great to be back.
So today's episode is looking at cyber attacks and specifically how to respond if you are the subject of direct attack, key considerations for GCs and CISOs, and specific issues arising in the context of financial services. Nicola, you joined us about a year ago now, and prior to that, you spent a number of years advising on cyber, data, AI, and tech matters, a very large global banking group. So thank you very much for taking the time to talk to us today.
That's no problem at all. Happy to be here.
So let's take this chronologically. So if we focus on the first 24 hours to begin with, and what typically are the first indicators of a cyber attack, what would the immediate action be and what would you expect?
So it really does depend. And I know that's almost a little bit of a get out answer, but really sometimes there's a big bang effect where computers don't work, screens are black, or have a holding message from the threat actor, with a dark image and you've been ransomed or, blocked or something. And the company is in effect paralyzed and being held to ransom. They can't do anything. Everything is dark, black. And sometimes that's on devices as well as main computers. Other times it's far less dramatic. So you might have the IT are monitoring the systems in their normal way, and there's an indication of threat actor activity, which is quite exciting. Are they in? Are they out? What are they doing? What's their next move? Or perhaps sometimes there's certain systems or applications that are unavailable without an explanation, and that can be really confusing. For example, an example I've come across is where things like a monitoring tool, for example, an anti-money laundering tool, produces 40% less hits than average. And there's questions, is there an internal error? What's going on? Is this just coincidence? Or is this a cyber attack and someone's manipulating their data? So all of that leads to an excitement of an incident that we'll then be engaged on. I mean, it's important to note that cyber attacks can relate to many different circumstances. So there can be threat actors pursuing different objectives. It can be an internal person inside a threat. Sometimes they're acting innocently, total innocent mistake, didn't realize they were doing it. And sometimes it's acting maliciously. One of the most difficult incidents I've ever worked on, there was huge operational impact, and it was caused by human error. Basically, someone had done a really long shift and made a mistake, and that took out an entire system. So also, these types of incidents that can cause significant operational disruption can also be caused by an external supplier, and then we call that a vendor breach. Many of the principles are the same, but too much to talk about in this episode. So for this one, we're going to focus on direct attacks by an external person, so a threat actor. There's also many different types of cyber attacks, and they can come in different forms, as we've talked about data poisoning, etc. But for this one, again, we're going to focus on ransomware.
Great, that makes sense. So perhaps quick back to basics. Could you maybe explain what is a ransom attack, what are the attacker's motives, and what are they actually trying to do?
So ultimately, with a ransom attack, the attackers are trying to cause pain and havoc so that entities pay the ransom. But why they do this is for many reasons. I mean, hacktivism is big, and that's where they're trying to further a political motive by taking down an entity or even a sector. And often it's not about hacktivism, it's about crime. So for financial gain, funding their own illegal activities, wars, etc. Threat actors usually do their research too. So they'll hit companies when they know those companies have insurance to pay their ransom or have financial backing. And they'll also try and hit at a time when they know it will cause the most pain to customers of that entity, or for the teams supporting that entity internally. So, for example, hitting a payment provider on payday, triggering an attack on a Friday night before a bank holiday weekend when no one will want to work over the weekend. Traditionally, it was taking out IT systems when ransomware hit, triggering operational resilience issues. But often now data is involved as well. For those in the fintech space, the idea, obviously, that you can't provide a financial service can cause massive loss, huge reputational issues, but also regulatory breaches, and particularly if people are relying on your service, like, for example, to make payments, access their cash, etc. But as I said, now often these kind of attacks also include stealing data. The data is exfiltrated, and often the data on the servers that the entity still has access to is left encrypted and locked. So not only has someone stolen their data and all the ramifications of that, they can't access the data themselves as a company. And that can be in itself crippling. It could be all your customer files, your regulatory records, financial holdings. Often the data is regulated, such as personal data, highly confidential data, could be MMPI, other considerations to think about. And so companies are then put in this ransom position to say, we want to pay the ransom to stop that data being made public and to regain access of the data so they can function again. And they also obviously want to minimize, regulatory breaches and reputational impact.
Yeah. So I guess clearly understanding the technical and operation items you've just covered inform what the legal and regulatory risks are and actions that flow from that. So why don't we start by looking at this from a regulatory perspective? What are the key regulatory risks that I guess should be front of mind for GCs and CISOs?
Well, there's so many, but let's start with data. As I said, often data will have personal data within it that's protected by the GDPR in the UK and the EU. It may also contain personal identifiable information, PII, protected in the US. But for this FinTech Focus episode, I suggest we just focus on the GDPR angle. A ransom attack where data is accessed, even if it's not exfiltrated, even if the threat actor has just been in files and folders and had a snoop around, that is a data breach. And this means that the presence of threat actor on your systems in itself is an access in the data is a data breach. The same applies to unauthorized encryption of the data. So even if there's no evidence that they took the data, they uploaded the data somewhere else, but they encrypted the data, that is a data breach. And obviously, clearly, exfiltrating the data and taking it is a data breach too. All of these would fall under the GDPR. And so the first thing that needs to be considered is, does the company need to notify the data regulator? And there's a short deadline for this, which is without undue delay or where feasible, not later than 72 hours of becoming aware of the breach. Lots of discussion about what is becoming aware of the breach, but the only exception to this is if the personal data breach is unlikely to result in the risk of rights and freedoms of natural persons. So, i.e., it's not going to cause any harm, the fact that this data has been breached. In many occasions, companies will just notify the regulator just so they're not in breach of this 72-hour window and just hold the space to say we're looking into this further. Then companies also need to consider whether data subjects, i.e. the individuals, need to also be notified. However, this is often a longer process to establish exactly what has been accessed and what's the harm to the individual. A point to remember for the fintech world, though, is that notification is around enabling individuals to protect themselves. So therefore, so things like identity documents, payment mechanisms have been impacted. Swift notifications might be key. That all being said, though, there is a balance to be struck between notifying quickly and also taking a breath and determining if a notification is really necessary, and if so, to whom. I mean, I've advised on many incidents where notifications have gone out in a bit of a panic, sometimes to hundreds of thousands of people, where that wasn't necessary, causing reputational impact, etc.
Yeah, I mean, that's a huge number of people. And I guess it really emphasizes the need for companies to think more broadly about their communication strategy and then also how they manage and handle news agencies, corporate partners, investors, and so on in terms of actually them finding out.
Yeah, you're absolutely right, Joe. I mean, communication strategy is a massive part of instant response, particularly around personal data notifications. It needs to be well coordinated, but also considered from a legal perspective to ensure you're not stepping into a legal pitfall with what you're being said, such as admitting a regulatory breach.
Okay, so that's data. Perhaps walk us through some of the other key sets of regulations that are relevant to fintechs.
Yeah, absolutely. I mean, obviously, we've got the wealth of financial regulation and particularly the obligation to have a continuity of service when you're providing a financial service is key. Financial services is a key sector to the economy. So there is a lot of focus on regulators on operational resilience at the moment. I think you did an episode with my fantastic colleague Suzanne on DORA recently, came into force on the 17th of January. And DORA has very strict and short instant reporting obligations where a lot of information is required to be notified to the regulator in a very short time frame. In the UK, although we don't have DORA, the FCA and PRA do expect an open and transparent relationship and often would expect a swift notification of any incident which may impact operations and the delivery of financial services. And on top of this, companies need to think about the coordination of these notifications, not just in relation to the financial regulators, but also to the data regulators to ensure consistency across the regulators and then also across the jurisdictions that they might be present in.
Understood. So I guess in terms of regulatory engagement, you've talked us through the approach with data regulators, and that's clear. And you've also briefly touched on the FCA and PRA from a financial regulatory perspective. I guess sticking with that, could you walk us through the typical notification strategy for financial regulators like the FCA and PRA, the extent to which there is an ongoing dialogue, and what firms should expect from that?
Yeah, of course. So in my experience, it's advisable to notify the UK financial regulators quickly. There is an MOU in place between the ICO and the FCA, and regulators can and do share information. So obviously, if you're notifying the ICO, you might want to notify the FCA at the same time. But also, in addition, the financial regulators don't want to hear about an incident through rumour, through the press, from another regulator, from a regulator in another jurisdiction. It's better to manage the narrative yourself, to have that open dialogue. And depending on the severity of the incident, this may be a regular check-in or may require specific email notification. That all being said, again, though, you don't want to over-notify. You want an open and transparent relationship, but you also need to protect yourself slightly. And the content of the notification, whether this is informal or formal, should be carefully considered with legal counsel.
Okay, so sticking with comms, because it strikes me that from everything you've said, this is really one of the most key work streams when you're dealing with an incident. Presumably there's going to be a whole raft of stakeholders that will need to be informed, and that may be driven by a range of factors, whether that's a legal requirement for impacted data subjects, contractual undertakings for vendors, regulatory obligations for consumers, or, for wider PR concerns. How are you seeing financial services firms handle this? And to what extent is the comms plan typically, pre-baked in existing cyber response plans?
So, in my view, it's vital to have a comms playbook drafted in advance. I mean, I've advised on an incident where my associate and I have been up all night on the night of the incident drafting a comms playbook because they haven't got one in place. And it's something that you do need to coordinate to have a consistent message, to make sure you're telling people what you're telling the regulators, that it's all aligned and you've got your story straight. The comms playbook doesn't need to cover every outcome and event. As I said, there's lots of different things that can happen, different timeframes, but it should have pro forma templates with sample wording for a range of incidents. It should also have details of things like your social media accounts, which you might forget about, mailing lists, customer groups. And also remember, you might not have access to your normal technology. So it's great to have it in another place in kind of like a battle box with it printed off so you can refer to that easily using different technology if you need to. It should also have sample wording for updating staff. And this is a bit of a bugbear of mine. It's something I mention all the time to clients, but I have seen several incidents where companies neglect to update staff, and staff are often the ones who are customer facing. And so going to get the telephone call if services are disrupted, not accessible. But even if they're not customer set facing, they'll usually have contacts in the marketplace, and they'll also have their own social media accounts. So you might not be able to tell staff any material updates due to the nature of the incident. It might be very sensitive. You need to keep it confidential. And I'm not saying overshare at all, but it is vital to tell them something, even if it's just something like, systems are down, we're investigating, don't say anything on social media. Give them sample wording, agree this in advance in relation to your comms playbook, and give them a contact point who they should reach out to. And like I said, just reminded them not to post anything on social media.
Good point. I guess let's rewind slightly and go back to the ransom, and specifically the topic of paying the ransom. I'd have thought, particularly in the financial services space, there'd be a huge kind of sensitivity and a whole raft of compliance concerns in actually making that payment.
Yeah, you're absolutely right. I mean, it needs to be really carefully considered on a case-by-case basis. Different laws obviously apply in different jurisdictions, and companies need to navigate all of these. These can be sanctions regime, finance of terrorism, anti-money laundering. Some laws have got strict liability where others require actual knowledge. So this can also therefore influence the strategy on how much information you get from or you seek and you try to obtain from your forensic experts.
So I guess in practice, how do you actually see organisations getting comfortable making the payment?
So by obtaining specialist legal advice, such as our Skadden white-collar team, or seriously, it's a really detailed analysis that can't be taken lightly. Clients do get comfortable and many do pay, although increasingly we're seeing the resistance not and resistance to payment and choices not to pay. The UK government proposals on mandatory reporting of ransom and requiring approval from the NCA before payment is an interesting development here. If you've not seen it, the consultation is open until the 8th of April. I mean, I've heard very many different views on this proposal, but in reality, ransom attacks is a huge criminal industry and something does need to be done and to change to tackle it.
So given everything we've just covered, we've already talked about there being a comms plan, which would need to be implemented in short order. But what else are clients doing in anticipation of an attack, and how does your team at Skadden help with that?
So many people now say that cyber attacks on companies is a certain. So they no longer talk about if we're hit, but instead when we're hit. And at Skadden, we can't help with that part. We can't stop you being a target of a cyber attack or caught in the crossfire or having a significant vendor breach. However, what we can do is significantly reduce the regulatory scrutiny and sanctions, reputational impact, and risk of resultant litigation from a cyber attack. As part of this, we're helping many clients refresh and revise their incident response plan, building in updated regulatory reporting obligations and expectations. We also assist on retaining specialist vendors' critical support in advance of an incident and underprivileged where that's possible. And the last thing you want to be doing in the first 48 hours of a cyber attack is negotiating terms with your key specialist forensic support team. We also often do things like host specialist tabletop training sessions, helping teams really prep for an incident and to understand their legal considerations, but also evidencing that the board has the requisite knowledge as required by regulators, either under senior management's regime or DORA. I mean, preparation is key, and even more so for fintechs, given the regulatory environment and personal liability under the SMCR and DORA, etc. So this is an area we think we can help. So think of us. Understood.
Well, Nicola, thank you very much for your time.
Thanks, Joe.
And as always, thanks to everyone listening, and see you next time.
Thank you for joining us on FinTech Focus. If you enjoyed this conversation, be sure to subscribe in your favorite podcast app so you don't miss any future conversations. Additional information about Skadden can be found at skadden.com.